So thank you very much. Very welcome to be here. I appreciate the introduction and very much appreciate the opportunity to speak. So I'm going to get straight into it. I just kick straight off into kind of the agenda. So just to set the scene a little bit, really, what we're going to talk about over the next kind of 30-35 minutes. It shouldn't be too much more than that. So I'm going to start off really with just a brief recap of the history of Brexit and kind of how it came about, how the laws are going to change or are changing, and what that means from a practical perspective for organisations. So it's the kind of the practical steps that hopefully you'll be able to take in order to make sure that your organisations are as ready as possible for the changes that Brexit is going to create. Now, I appreciate that I think we've got people from kind of all over the world in terms of watching the webinar. So it's mainly really for organisations that are kind of based within the EU or have got subsidiaries in the EU or transferring data to and from the EU. So all of these things are going to require changes as we go along. So we'll talk a little bit about these new issues that you need to consider, and then what we'll do is we'll finish off with just a kind of checklist of steps that your organisation is going to need to take before Brexit is finalised. So, and then hopefully we'll have about 10 minutes on the end in order to answer some of your questions. So, in terms of this, the brief recap, it's kind of how did we get here? So, how is it that we managed to get in a situation where the UK is actually leaving the European Union? So, the UK held a referendum on its continued membership of the European Union way back in June 2016, and the kind of largely unexpected outcome of what was the public vote was that the UK would leave the EU, and the vote was by about a margin of about 4%, so reasonably close, but certainly quite unexpected. And so the UK government announced that following that, the wishes of the people, that it would trigger what was called Article 50. So this is the clause within the European Union's Lisbon Treaty, and it's the one place really where that outlines how a country can actually leave the bloc voluntarily. So an Act of Parliament was required to do that, and we invoked Article 50 on the 29th of March 2017. So, and this was supposed to begin only a 2-year process that we all now kind of refer to as Brexit. But what it should have meant was that we were supposed to leave on the 29th of March 2019. However, due to lots of political wrangling, which I'm sure most of you saw play out on the news, or rather slightly embarrassingly for the UK, but we didn't have the majority. The government didn't have the majority in order to get it through Parliament easily, and therefore, in order to try and do so, we had to extend that deadline from the 29th of March, first off to the 12th of April, a couple of weeks later, and then we kicked it down a bit through to the 31st of October. But that still didn't succeed. But thankfully, we did call a general election in the UK in December of 2019, and that thankfully did give us, or gave the government, the Conservative government, the majority that they needed in order for the bill to pass through Parliament. And therefore, we did finally leave. So we have actually left the EU, which was on the 29th of January this year, so a few months ago. So we are now in an 11-month transition period from that 29th of January through to the 31st of December. So, and it's a period that's been catered for in order to enable the final negotiations to take place relating to the UK's future relationship with the EU and working out kind of what that's going to look like. So at 11 p.m, so that's UK time, obviously midnight in the EU, the UK, on 31st of December 2020, that's when the whole thing kind of comes to an end. it can be extended for up to a period of a further 2 years, because we've got a lot to be done. There's a lot of negotiation to be done. There's trade agreements, there's issues around data protection and many others that need to be resolved before the official kind of end of the transition period. So there is a caveat in there that would enable us to extend it for a further 2 years, and to a degree, everything that's going on with COVID-19 at the moment may well mean that we do increase the likelihood of it being extended. But the UK Prime Minister, Boris Johnson, has made it really quite clear that he wants to get Brexit done, and therefore there is a political will to make sure that it does actually happen on the 31st of December. However, what the exact landscape is going to look like after the 31st of December is still pretty unclear. There are bits and pieces coming out, but we're kind of just trying to make decisions along the way. So some of this is a little bit grey still, but hopefully as the weeks and months go by, especially once hopefully we're a little bit through the COVID period that we're going through in the UK, things will start to become a little bit more clear. But there's definitely plenty of unknowns that need to be finalised before the end of those negotiations. So the expectation is that many of the EU laws will actually become UK laws, or at least initially at least. So statistically, there's been about 230 different laws introduced into the UK that are based upon EU obligations, and apparently 62% of them have been introduced since 1993. And obviously, the purpose of this webinar is only really data protection. So I'm only really going to be focusing on the GDPR, so the General Data Protection Regulation, as that is obviously the main data protection regulation that we are all trying to comply with. And as it stands, from a practical perspective, we are currently in a situation where we have the EU GDPR, and we also now have an identical UK GDPR. And there's a reason for that, and the UK published a document which I don't know off the top of my head, so I'm going to read it to you. It's called the Data Protection, Privacy and Electronic Communications Amendments, etc. EU Exit Regulations 2019. So slips off the tongue nicely. But these are there to amend the Data Protection Act. So the Data Protection Act is the UK law that enacted the GDPR into UK law back in 2018. And what it does, what that document, or the regulation I just described there, is it enables the UK to amend the Data Protection Act. So everything that was saying C EU GDPR is now saying C UK GDPR. So all of those references are getting updated. So fundamentally, until we hear otherwise, the GDPR is here to stay in the UK as a UK flavour, but certainly the GDPR. So it's not like the UK is kind of scrapping the GDPR and just relying on its own laws. So it's very much here to stay. So what it means is that if you transfer data to and from the UK and or the EU, you are going to need to consider. The expectation is that many of the EU laws are going to become UK laws. So, but not all of them. So, as it currently stands, we are going to have a UK GDPR, and we're going to have an EU GDPR. So, we need to update what's called our Data Protection Act, so that it no longer points to EU GDPR, it points to UK GDPR. So from January 2021, we're going to have 2 times GDPR that we need to comply with. So both an EU GDPR and a UK GDPR. So if you transfer data to and from the EU and the UK, then you're going to need to consider one or the other or both of those regulations. What's kind of likely is that over time, the two regulations are going to diverge. So the European Commission and the UK government will periodically review those laws and make changes. The various decisions that are going to get made by the EU regulators, especially where those decisions differ between the EU and the UK Information Commissioner's Office, the ICO in the UK. So difference of opinion are going to get created. And of course, there's going to be a body of case law that starts to build up over time. So, organizations need to be sure they understand those deviations and how they're going to affect them and their processing activities across both of those separate jurisdictions. We need to talk a little bit about adequacy and becoming a third country. So a third country is any country that is outside of the EU. Which means that the UK is going to become a third country once Brexit is complete. Now, how much of an issue this is for the UK in terms of data transfers depends on what's called an adequacy decision. So now the UK government has performed a bit of research and they've calculated that exports of personal data enabled services from the EU to the UK are worth about $50 billion per year, well, at least in 2018. And exports from the UK to the EU are worth $103 billion. So in fact, it's probably more in the EU's favour, or at least that's the picture they're trying to present, that the EU takes a favourable view from a commercial perspective to awarding the UK an adequacy decision. So, but it is very much in both parties' interest to keep data flowing freely, because obviously free movement of data means that you've got a much less friction involved in doing business with our European counterparts. So, however, adequacy decisions are made by the European Commission, and the parameters of these are set out in the GDPR's Article 45. And typically, decisions by the European Commission take around 18 months in order to make an adequacy decision one way or the other. So effectively not within the 11-month transition period that's currently ticking away. So, and the EU was very adamant that they would not start an adequacy decision process until Brexit had actually been activated. And the problem that we have is that the UK is currently 13th in the queue of countries that are awaiting an adequacy decision. And those adequacy decisions are based largely on the protections that are available from the laws within that country. So surprisingly, even though we are now currently part of the EU or coming out of it, it's by no means guaranteed that the UK will get adequacy as a result of the negotiations. And so the UK's put forward its case, and it's published a document called it's the Explanatory Framework for Adequacy Discussions, and it sets out kind of why it thinks the EU should award the UK an adequacy decision, and certainly quickly. But at the same time, the UK has introduced its Coronavirus Act, as many member states and other countries are doing. But ours envisages at least increased surveillance powers and things like the bulk requests for telecommunications data and things like that. So these are going to remain during that evaluation period, and therefore they might, kind of present a few roadblocks in the way in terms of that decision making that's going to get made. And so, it's going to be a bumpy road. It's going to be full of potholes. And it's by no means guaranteed that we are going to come out of it with adequacy prior to the end of that transition period. What if we don't get adequacy? So where a country is considered adequate, it means that data could be transferred to that country on an unrestricted basis, and therefore you don't need to implement what are called additional safeguards. So, what if the UK is not considered adequate, even if it's only temporary? I mean, remember, we are in the queue. It will happen most likely at some point, but it may not happen in time. And of course, if we reach the end of the transition period and it hasn't happened, then these additional safeguards are going to need to be introduced, even if it's kind of temporarily, if you like, between the end of the transition period and when the decision is finally made. So what it means is that all personal data transfers from the EU into the UK are going to require additional safeguards to be implemented. Now, the UK has already stated that it will consider the EU to be adequate alongside any other countries that the EU has considered adequate prior to the end of the transition period. So, which means that transfers from the UK to the EU are unaffected by Brexit. So, if you're interested, the 12 countries, which I don't know off the top of my head, but I'll give them to you. It's the current adequate countries are Andorra, Argentina, Canada, Faroe Islands, Guernsey, Israel, Isle of Man, Japan, Jersey, New Zealand, Switzerland, and Uruguay. And we are expecting a decision regarding South Korea to be made prior to the end of the transition period. So there might be a kind of 13th country added to the current list of adequate countries. Now, you may have noticed I haven't mentioned yet the US, but I'll come on to that shortly, as it's something that we need to deal with kind of specifically. So in terms of gaining adequacy, it does not require the country to have identical data protection laws to the GDPR, but they must provide what's known as essentially equivalent protection. So any of those 12 countries that I mentioned there, they have demonstrated that their laws provide that essentially equivalent protection. So it's by no means a done deal that the UK is going to get adequacy. So the problems of doing so are not simple, and it's due in part to a particular law we have in the UK called the Investigatory Powers Act of 2016. And then this particular act was described rather unfavourably as the most extreme surveillance legislation ever passed in a democracy. Therefore, this is one of the issues it's likely to fail one of the tests, which is the general and indiscriminate collection test that the Commission uses as part of its adequacy evaluation. So, but of course, I get asked quite rightly, quite often, how come, if the UK is effectively adequate and is transferring data backwards and forwards in between the EU today or on the 31st of December, but come 1st of January, how can it all of a sudden no longer be adequate? So that is in part down to Article 4 of the Treaty of the European Union. And in that article, it states that national security remains the sole responsibility of each member state. So it's effectively being excluded. But of course, that's only whilst the UK is part of the EU. So it means that the Investigatory Powers Act is being ignored whilst we remain in the EU, but as soon as we come out, then of course it's not. And at the moment, the Court of Justice of the EU, or rather the European Court of Justice component of it, is the highest court in the land. So anybody that wants to have an issue with the way that the UK is proceeding can take it to the ECJ. But of course, when we come out of Europe, the highest court in the UK will be the UK's Supreme Court. So the EU loses its ability to, or EU residents, data subjects, lose their ability to take it through the EU court system. So fundamentally, it's going to be a completely different legal environment to consider from the 1st of January 21, and hence it's an entirely new playing field when it comes to awarding an adequacy decision. So the UK will, I suspect, need to make quite a number more further amendments to the necessary laws in order to provide the kind of assurances that the European Commission is looking for before we actually get given that award of adequacy. What's the effect on international data transfers? So the first question that you need to answer in this respect is if you're making what's called a restricted transfer. So it's a transfer that will require additional safeguards to be implemented. So these are transfers of personal data to locations outside of the wider European Economic Area. So if you're inside the EU and you're making transfers out, then these are going to be restricted transfers. Now, the European Economic Area is essentially the 27 remaining member states plus Iceland, Norway, and Liechtenstein. So what it means is prior to the transfer, you're required to consider if you're able to achieve your aims without actually transferring the data out of the country in the first place. So, if locating the data within the country is a viable option, then the law requires that you take it. So, there might be some easy wins in that respect. So, if you're using something like AWS or Azure, then it should be a relatively straightforward exercise of just kind of adjusting your region tenant so that within inside your account, so that it kind of everything gets hosted in the UK or in the EU, depending on where it needs to go. But if that's not possible, and obviously it's not always as simple as that, then what you're going to need to do is to most certainly create a data map in order to understand the data flows and to ascertain which countries you are transferring data to and from. Now, this is an exercise that some of you may have performed before the GDPR was introduced, and that's great. But it might need updating, or if you haven't done it yet, then certainly it is something that is pretty fundamental to your ability to manage your GDPR compliance, but also certainly your anything to do with international data transfers. So when you draw that map, the question you're looking to answer for yourself is, is the data, the personal data, located in an EU member state, or is it in the wider European Economic Area, or is it located in one of the current 12 countries that are considered to be adequate that I mentioned earlier, or is it located in a third country? So none of those countries. So if it is in a third country, the next question is it subject to something like Privacy Shield, which I'll come on to in a minute in terms of the US, or some other approved code of conduct? So, or is there a specific exception or a derogation that applies? And that's things like medical emergencies, and national security. So they're quite rare situations. So, but if not, then out of all of this, whenever you identify that you are transferring data to a third country, then you're going to need to incorporate what are called standard contractual clauses, or SCCs, and these need to be put into your existing or your new agreements in order to make those enable those safeguards to be put in place and legitimize that transfer. Now, SCCs, they're sometimes called model contract clauses, depending on who's talking about them, but SCCs and model contract, they're all essentially the same thing. So after Brexit, so after the end of the transition period, and if the UK is not awarded adequacy, then standard contractual clauses are going to need to be implemented with all of your EEA, so your European Economic Area vendors and partners and suppliers, all the people you're working, all the people you're transferring data to, and that needs to be put in place prior to the end of the transition period. So at the moment, that's the 31st of December 2020. So there's a reasonable amount of work, depending on the size of organisation you are and the number of different partners that you're working with, where you've got to get that kind of put in place, ready for if we're not going to get that adequacy decision. If we do get it, then it's not necessary, but maybe something that you need to be, certainly something that you need to be considering now. So those standard contractual clauses, they're freely available to download. You just have to Google for it, and you'll be able to find them. but the important thing is that they have to be included into all of your agreements in their entirety. So they can't be amended. You have to accept the terms and, of course, abide by those terms in terms of the transfers that you are then subsequently making. So, there's currently 28 member states, if you include the UK for the moment, each of which has their own independent regulator. And these regulators agreed that they would introduce this mechanism that's called the one-stop shop. And it was implemented for situations where organisations that have their main EU establishment in a single member state, so for example, the UK, but they process data across multiple member states. So what it would mean is that in the case of a breach, you only need to deal with a lead supervisory authority or regulator, and not every individual authority from every member state where the data subjects that have been affected by that breach are kind of located. So you choose your primary supervisory authority, and that's the one that you're going to deal with predominantly going forward. However, as it's currently understood, after the 31st of December, the UK's Information Commissioner's Office, the ICO, will no longer participate in that one-stop shop mechanism. So and they're also not going to have a seat on what's called the European Data Protection Board. So it's a committee that was created. It's got representation from each of the regulators across Europe. And there's a good chance that the ICO, they might continue to participate in the EDPB, but only on a kind of advisory basis. So they won't be part of any decisions made. So the ICO is kind of out of the European Data Protection Board as of the 31st of December, or if it's extended. So what it means is that organisations that are currently using the ICO as their lead supervisory authority, what they're going to need to do is they need to evaluate the processing that you're conducting. And it's looking at what you're doing in other member states. And as a result of that, you need to establish, based on that processing, who should be the new lead authority, if you're able to. And if you can, then you should be updating your privacy policies to reflect that decision. But the problem is that in a lot of cases, it's not really possible, or there isn't really one member state. You just kind of have data across the EU, so it's quite difficult to, or not possible to nominate that single one-stop shop. Whereas if you had your head office in the UK, the obvious choice was, or your regional office, sorry, in a subsidiary in the UK, the obvious choice was the ICO. But once you take the ICO out of the mix, maybe there's no obvious choice left. So where that's the case, you're just not going to be able to take advantage of the one-stop shop, which means that in the case of something like a breach, you might need to deal with multiple of the EU's supervisory authorities, as well as the UK ICO separately, and potentially it does open the door for enforcement action from multiple supervisory authorities. So multiple penalties and multiple enforcement action. So let's deal with Privacy Shield, which I've been mentioning or referring to a little bit as we go along. US data laws are basically not considered to be essentially equivalent to EU data protection laws. Now, I know there's a lot going on. Obviously, you've got CTPA and lots of different flavors of that happening, and as time goes on, I think that's going to change. But currently, that's kind of not the case. So the US is not considered to be an adequate country by the EU. But of course, the vast majority of the EU's data is, or at least was, being stored and processed by large US organizations, and therefore it was clear that a mechanism needed to be put in place to enable that. So the Privacy Shield framework, it started as life as a different name, but the current facility is called Privacy Shield. And it was created to provide a mechanism under which personal data can be transferred from and to the EU and the UK and the US. So Privacy Shield is a self-certification system that US organizations can enter into. It consists of 23 principles that kind of obligate that organization to comply with the EU's data protection requirements. So on top of the US data laws, you're agreeing to those 23 principles. So in terms of UK and US data transfers, it's absolutely business as usual until the 31st of December or whenever the transmission ends. I don't know if you've lost me again.
No, we can hear you.
You can hear me, okay, good. So in terms of the UK and the US data transfers, it is business as usual. But after that date, in order for Privacy Shield to continue to apply to UK and US transfers, UK organisations will need to confirm that that Privacy Shield member has amended their public commitment to state that the Privacy Shield principles have been extended to data that's being received by the UK. So it's a job that kind of needs to be done. So if in your data map, if you've identified what's going on, then you need to make sure that they are actually conducting that as to make sure that that has actually been done. And then also UK organisations should also be confirming that they've renewed their membership on an ongoing basis. It's something that your data protection officer, if you've got one in the EU, or in the UK, certainly needs to be checking and confirming that it exists on an ongoing basis. So a little bit about appointing a data protection officer. So it's Article 37 of the GDPR that states when it's necessary for an organisation to designate a data protection officer. And in certain cases, it obliges an organisation to create that role. But what it does not state is where a data protection officer kind of must be located. So some member states, such as Germany, they have much more strict rules in this regard and have done actually since prior to the introduction of the GDPR. But the GDPR states that your DPO must be easily accessible from each establishment. So, but the European Data Protection Board recommends, in a way, kind of as it would, that assuming you're processing data in the EU, then your DPO should also be kind of located within the EU. So all it means is that the more cautious organisations with only a UK DPO currently, who are processing a lot of data in the EU, that you might want to look to move or duplicate your DPO role in maybe the UK and the EU as well. But if you do move the location of your DPO, obviously make sure that you don't forget to inform whoever is your lead or relevant supervisory authority of their kind of new contact details. So something else alongside appointing a DPO, you may also need to appoint what's called a representative. So it's Article 27 of the GDPR that deals with the need for a representative. And representatives are required by organisations they're based outside of the European Economic Area, but they have no physical presence inside the EEA. So it applies to organisations that are offering goods or services, or they're monitoring behaviour. So it's a few exemptions in terms of things like a public body or authority, or if the processing you're doing is occasional, so it doesn't present a particular risk to the rights and freedoms of EU residents. or it doesn't include the special categories of data or criminal records that are defined by Article 9 and Article 10. So it wouldn't affect an organisation that is processing very small amounts of data on EU residents, but it could do if the data that's being processed is kind of health related. So an example would be a pharmaceutical organisation, something like that, that's conducting a clinical trial in the EU, so has data subjects in various countries around the EU. Of course, when you're conducting a clinical trial, you are collecting the special category health data, and therefore, even though you're dealing with what is actually a very small number of data subjects, it does mean that because of the type of data that you're processing, you would then need to be looking to appoint that representative. So a lot of organisations do fall within that definition of needing to appoint one. And it's important really to note as well that the role of the representative is actually very different from the role of a DPO. So if you already have a DPO, it doesn't necessarily have a bearing on whether you're going to need to appoint a rep or not. And the reason for that is that a data protection officer is appointed to kind of act independently on behalf of the data subjects you process data on, whereas a representative acts under a kind of written mandate. So they perform what is essentially a very different task, and they fulfill very different legal obligations. And so that representative is there to facilitate communication between the EU resident data subjects and you as the organisation. Cooperate if anything comes up, with the necessary supervisory authorities. So answer any questions that they may have about the processing activities you're conducting within the EU. They're obliged to maintain a copy of what's called your records of processing activities. So this might be something that a lot of organisations have already put together. It's defined by Article 30 of the GDPR, but it basically enables you to articulate what you're doing with what data you've got and what you're doing with it, who you're sharing it with, and how long you're keeping it for, and everything you kind of need to know in order to manage that data. And that representative will appear as your point of contact on your privacy policy. So data subjects know how to contact you in the EU. So the representative that you appoint has to be established in a member state relevant to the data that you're processing. So, for example, if you only process data on, say, French data subjects, then your representative should be established in France. So established is a slightly woolly definition, but effectively it means that your representative will be based in France and be able to deal with, from a language perspective, issues that come up in that particular member state. So returning to the fact that we are going to have 2 times GDPR after Brexit, remember? So we're going to have the EU GDPR and we're going to have the UK GDPR. It also means that, unfortunately, we're going to have 2 times Article 27. So hence, if you process data on both UK and EU residents, then in all likelihood, you are going to need to appoint a representative in both of those jurisdictions. Actually, a final point on that also is that appointing a UK representative is irrespective of the adequacy decision. So, so with or without adequacy, at the moment, that representative is still going to be required. It does depend a little bit on whether the UK drops that requirement when it fully adopts the UK GDPR in the way that it is. But at the moment, that is the requirement that organisations are going to need to comply by. So just to kind of briefly summarise, so if you process, or if the data that you process is going to be affected by Brexit, then a list of kind of recommendations that you need to take are, first off, very much start with that data mapping exercise. Map those data flows understand where the data comes from, who you are transferring it to or sharing it with, and make sure that you kind of understand the various transfers that are involved in all of the data that you process that involves certainly EU residents. Now, in the absence of the adequacy decision, if you are transferring personal data from the EU, then you're going to need to ascertain which of the safeguards that you need to have in place. And of course, standard contractual clauses are the ones that are the ones you're most likely going to want and need to use. So if you're processing both EU and UK personal data, and the ICO is currently nominated as your lead authority, then you're going to need to decide who your new EU authority is going to be. And you need to ascertain whether you need to appoint an EU or a UK representative, or both, depending on the data that you're processing. Now, if it's not something you've already done, a lot of you may have already done this in the course of your GDPR preparations a couple of years ago, and as you've introduced new systems and so on. But of course, it is necessary to conduct what are called data protection impact assessments. So these are it's a mechanism that's kind of detailed in Article 35 of the GDPR, and they're used to understand the risks associated with your processing. So they're especially required if you are processing sensitive special category data. So that's the Article 9 and Article 10 data. And if you conduct that DPIA, then you will need to either construct or update your records processing activities based upon what you find out according to those impact assessments. And then you will also, hopefully, will have created policies and procedures such as breach procedures and notification protocols. And so you're going to need to take into account that the new jurisdictions and the new requirements that the UK coming out of the EU are going to create, and make sure that they've been updated accordingly. And then finally, once the transition period ends, you're going to need to update your privacy policy to reflect the UK's new third country status. So it's just another kind of minor update to your UK privacy policy to recognise that the UK is now a third country. So thank you very much. I hope that covered a bit of a whistle-stop tour, but hopefully that covered most of what you're needing to know about Brexit.